Good evening. Hi, I'm Felicia Simmons Stovall, member of the Cook County Bar Association. The CCBA is the oldest African American Lawyers Association in the country, and you are watching CCBA Live on CAN TV 21. We are streaming also online at cantv.org/hotline. For the next 25 minutes, we will be discussing landlord-tenant issues. So feel free to call in at the number at the bottom of the screen, 312-738-1060, with your comments or question. So today, I'm joined by Kelly Garner. Kelly, you want to introduce yourself?
Yes, I'm Kelly Garner. I'm also a member of the Cook County Bar Association, and I have represented clients in areas of real estate, dealing with all type of landlord-tenant issues. So we look forward to your questions if you have any of those, and I look forward to learning some of the information Felicia would have to share with us as well.
So, again, I am Felicia Simmons Stovall. I'm a practicing attorney. I've been practicing for 21 years approximately, and I practice in the area of landlord-tenant issues, family law issues, security law, a couple other things. But today we're going to be talking about landlord-tenant issues. So to begin with, and what's important is that the landlord-tenant issues that we face here in Illinois is governed by both federal statutes, state statutes, as well as local statutes. And one of the statutes that many people are familiar with is the Chicago Landlord-Tenant Ordinance, which has been in place protecting the rights of both landlords and tenants since 1986, I believe, Kelly. So the Chicago Landlord-Tenant Ordinance applies to units of any rental units in the Chicago area that has 6 or more units and that are not owner occupied. But there are some other acts or some other laws that also protect the rights of both tenants as well as rights of landlords, and some of the things are like the Eviction Act, which a lot of us are familiar with, the Forcible Entry and Detainer Act. Any others you could think of, Kelly?
Yes, the Fair Housing Act.
That's another
the
one.
Security Deposit Return Act.
Which is a big one.
And the Illinois Residential Tenants Right to Repair Act.
Yeah. The other thing, too, is just not many times you see people who face issues outside of Chicago, but there are a number of suburban areas that have ordinances as well that are in place. Like Evanston is one I know for sure that has a landlord-tenant ordinance that protects its tenants as well. I believe Maywood has one as well. So there are a number of other municipalities that have ordinances in place that will protect landlords as well as tenants.
And I think one of the very valuable things that you stated for our listening audience, Felicia, is that federal and state laws protect as well. So they would cover some of those municipalities by protecting them under those relevant laws and statutes.
So I guess one of the things we wanted to begin talking about today is what issues that individuals face with regards to landlord-tenant issues. And one of the biggest things that we hear oftentimes would be evictions. And so with evictions, one of the things that we must understand is that tenants have rights. You just can't be locked out, for instance. And if you're locked out, there are some remedies that an individual can have, which would be...
You can actually call the police if you're locked out, because while you are renting a unit, you have the right to access to that unit. You can also call other different legal agencies that can support you, but in that immediate instance, when you need to get in your home where your personal belongings are and where you've been paying rent, you can call the police.
And that's key, because a landlord cannot come in and say, I'm going to change the locks, or I'm going to cut off your services, your essential services. I'm going to cut off the gas. I'm going to cut off the lights. A landlord cannot do that. In order to evict you, they have to properly evict you. They have to follow the law. And so it's very important as a tenant that you understand your rights. You don't have to accept something that happens, or you don't have to be afraid to assert your rights. So in that particular case, like Kelly said, if your landlord changes the locks on you,
Call the police.
Call the police. There are other issues too, or other things that occur when when a tenant is faced with some issues. Say if something is broken in the house.
Right. The tenant in that instance should give their landlord some sort of notice that the item is broken. And depending on how serious the issue is, like if it's a water heater that's broken and all their water is cold, they have the right to get their own repairman in and to deduct the amount of that repairs from the amount of their rent. But first, give the landlord 24 hours to correct the issue and stay in close communication with the landlord. So when you set up your initial lease, set up a good line of communication. You always want a working phone number for your landlord and a way to communicate with them. If they don't text, texting them in an emergency is probably not going to be effective. But if they have a number and it's not working for whatever reason, then you know you're going to have to take matters into your own hands in forms of making your unit livable for yourself. But be sure that if you spend any money on a repairman or anything of that nature, that you maintain a receipt and a record of your notice and your efforts towards notice, if you ever need to explain those to either the landlord or to a court.
Then one thing I also find, and we were discussing earlier, is that when you have an interaction or communication with your landlord, make sure it's in writing.
Exactly. People often take for granted that they have this familial relationship with their landlord. This is someone who owns the place where they're sleeping. And they always hear oral contracts are valid. Although that's true, real estate's governed by the statute of frauds where everything needs to be in writing. So you may have an oral contract, but it's very difficult to enforce something that you can't touch. The more tangible it is, the more useful it is in all areas of real estate, especially landlord-tenant law. So you want your landlord to have issued a statement as to how to communicate with them. So if you follow that and keep a track of that, then it's believable to your landlord and to the court. And if they fail to update you as to that communication, then that's on them, not on you. You need to maintain your own type of communicative devices as well. If you change your phone number or anything of that nature, you should also let your landlord know that. In the case of an emergency or just to communicate on issues concerning the property, they may need to get in touch with you.
And it's a good thing that you say that, because another thing that comes to my mind is that you have a right to know your manager's information, so contact information by law, that should be disclosed to you. You have a right to know a phone number where the manager or the landlord can be contacted if something like that occurs. So it looks like we have a caller on the line.
Oh.
Go ahead, caller.
Good evening, ladies. My name is Carla, and I'm calling from Riverdale. And you guys are doing a wonderful job.
Hi, Carla. Thank you.
Hi. My question is, if I'm a tenant in a building where the owner got a reverse mortgage and the owner passed away, what rights do I have as a tenant with a lease or without a lease?
You want to take that?
Sure, I'll go ahead and take that one. Hi, Carla. If you do have a lease, you can provide the lender a copy of that lease, and you are entitled to live out your lease free from whatever the owner, which is then the mortgage company, is going to do to you. Also, you need to make sure that you keep in touch regarding information. You need to know if you find out that they die, give yourself a heads up. No, this is when my lease is ending, this is my agreement, because the mortgage company is not going to become an extended landlord for you. They're not going to enter into a further agreement. They're going to limit your rights to the terms of the lease that you have. But let them know those terms. If you haven't let them know those terms, then you may be facing a situation where you have to prove them at the last minute. Now, if you do not have a lease, they still need to evict you, and that's a process. They can't just change your locks or put you out or anything. And they'll send you information about that. They'll probably send you a 5-day notice or a 30-day notice. They'll be as courteous as they can, because they're not going to move that quickly. And if they're going to have the sheriff evict you, that takes a good deal of time here in Cook County anyway.Maybe 3 or 4 months. And in the winter, you might coast until March or April. But you never do know. But you can always ask. You can always ask a real estate attorney, you know, what's the put me out period with the county sheriff? And how much time do I have if they are going to go that route? Keep a line of communication for your own peace of mind and for the peace of your household. You don't want to start making anyone feel like this will come undone without understanding it. So as soon as you know that your landlord has passed, and you know that there is a reverse mortgage on the property and no one's going to take that over, then look for information from that lender. If you know beforehand that there's a reverse mortgage on the property, try to get as much information as you can from the lender in the way of communication. But if you check with a real estate attorney or you check with the real estate legal aid law office, they can help you just check your deed to see who owns the property and to see what's recorded against the property. And that lender's information will be there, at least their name. And FDIC is going to require, and Fannie Mae is going to require that they have a customer service representative that can walk you through this. But the best thing for you to have, of course, is as much information from your landlord as you can up front. And be open-minded. If you know that your landlord to be very, very ill, or if your landlord is 105 years old,
Correct.
Be open-minded about what your future living arrangements are going to be. Does that answer your question, Carla?
I think so.
Oh, good.
Thanks, Carla, for calling
Thank
in.
you.
So the other thing that we often, and we kind of just talked about it, touched on it earlier, was about security deposits.
Yes.
When you pay your security deposit to your landlord, and some people have questions. Well, do I have a right to have that back? Can I live my security deposit out? And there are things that you have rights to, like for instance, if your lease is ending and it's time for your security deposit to be returned, the landlord has 45 days to return that security deposit. If the landlord says that they want to deduct, say, the wear and tear on the apartment, they cannot take away wear and tear, but damages they can deduct from your security deposit. But they have to give you 30-day notice. So within that 30-day window, after your lease is ended, and you're like, well, yeah, I'm going to get my security deposit back, they have to tell you within 30 days that they're going to deduct money. And within the next 15 days, if it's something that's left over, you are required, or you can demand that money back after those next 15 days. And if they fail to do it, you can take them to court and you can get twice the amount of your security deposit. So that's one good thing. And then the other thing with the security deposit that pops in my mind is that some people want to live out their security deposit.
Felicia, when it comes to living out your security deposit, it's a bad idea to go into the lease thinking and planning on doing that. That's not to say that it doesn't happen.
It does.
That's another one of those instances where you really need to come to an agreement with your landlord ahead of time so that you can be prepared. And that's another instance where you need that in writing.
You need to get it in writing.
You really do. You also need to watch the condition of your property. If you're living out your security deposit and you know you've broken the faucet, then that's an item that you're going to need to pay for, because then you're liable for the condition of the property.
Yes.
Them allowing you to stay doesn't mean that you get to then destroy their property and they have nothing, no pot from which to pull any funds to repair from.
Right. And even when that happens, say if paint, that's another thing that some landlords attempt to take away from your security deposit. That's normal wear and tear. You've been in an apartment for 5 years, 6 years, and they want to say, well, we're going to replace the rug and take it out of your security deposit. No, that's normal wear and tear.
You know, Felicia, you bring up a very good point. Knowing what normal wear and tear is something that's available information to tenants.
Yes.
You can get this information at the touch of your fingertips. So know what normal wear and tear is. Know what is classifiable as damage.
Correct. I mean, if the window is broken, you are responsible for the window if it's something along those lines. But generally, paint, no, not at all. A rug, no, not at all. But again, as Kelly keeps saying, the communication back and forth with your landlord, make certain you communicate with your landlord to let them know if something is broken in the apartment and they need it to be fixed, communicate with your landlord in writing.
Absolutely. And writing is definitely important. And at this stage, be prepared for there to be some sort of repairs that you may not have necessarily anticipated. Don't think that you're going to get this security deposit back in full and you're planning on using that. You may be setting yourself up for a lack of preparedness and moving forward with your living arrangements, because you may have to do some back and forth to negotiate this security deposit. Landlords will definitely get everything it is that they're able to get. And if you don't challenge it, then there's nothing stopping them. And so they may take anything from half of it to all of it. So you have to be prepared. And in your move out process, broom clean condition goes a long way.
It does.
It really does. If you leave everything a disgusting hot mess and the stove is just reeking of grease and oils and the refrigerator is still full, and if they're doing a lot of cleaning up,
They're going to charge you.
They're going to charge you.
They're going to charge you. They're going to deduct it from that security deposit.
They are, and you're really limited when you leave it in that condition to what charge you means. They can use a service that'll cost almost half of your rent to
Absolutely.
really clean everything. So do your best to leave it in a condition that you would want to find it in if you were a landlord.
So that you can get your security
So
deposit
that you
back.
can get your security deposit back. And Felicia, in addition to your security deposit, you're entitled to a little interest.
That is correct. You have to, the landlord is required to put it in an interest-bearing account. And that's one thing that people fail to understand. It may not be a lot of interest, but it's some interest. And they cannot commingle the funds. They cannot put it with their funds. They cannot spend it at their liberty. They're supposed to set your interest in an interest-bearing account. Just like attorneys have to have client accounts, they have to set as a tenant. You have to have an interest-bearing account so that you can earn interest on your loan, on your security deposit.
I really like that you say that because you have the right to ask for a copy of that deposit.
Yes.
You have a right at any time during your lease, if you see that your landlord is just really not keeping up with things as they used to be, they're not there as much as they used to be, you have the right to say, well, wait a minute, I wonder if they have my money. And by law, they have to provide information regarding your specific deposit of security for you.
And that brings us to another topic, too, in regards to a tenant's rights and retaliatory evictions. Sometimes a tenant will stand up to not stand up, but assert their rights, I guess for lack of a better term, will assert their rights. But sometimes, oftentimes, that tenants may be afraid. I find that to be the case, and so they won't say anything. Or if they're on a HUD certificate, what's formerly known as a Section 8 certificate, sometimes that may occur, and they're afraid to assert their rights. But particularly in the state of Illinois, the city of Chicago, and a number of the municipalities across the board, as a tenant, you have a right to assert your rights.
Absolutely, and tenants should encourage the support of their municipalities. The city loves to protect you in that instance, so go ahead and bring it forth. If you have a wall that is coming down on you, you don't have to live that way. And the city inspectors will even come if they need to come. But you need to bring it to someone's attention. So again, bring it to your landlord's attention and get that information in writing.
It's like we keep saying in writing because that is so important. If you're writing, if the wall is coming down, you want to put it in writing to your landlord, the wall is coming down, and I expect this to be repaired in 14 days. Communicate that to the landlord. You can send it via certified mail. You can deliver it in writing in person. I would always suggest putting something or sending something to the landlord via certified mail. That way you have a receipt of what is sent. A lot of people communicate via email. You know, if you have your landlord's email, send it via email, but let them know XYZ is occurring in my apartment or my home. I would like it to be repaired. And if the landlord does not repair within 14 days, you give them 14 days to repair unless it's an emergency and it's a hazard. But ordinarily, you give them 14 days to repair. And if they don't, then you can repair it, and you can deduct that from a reasonable portion of it from the rent, and you want to keep receipts. That's the main thing. You want to keep receipts.
Absolutely, Felicia. You can't stress enough the importance of a record.
Yes.
And so photographs, everything it is that you have will assist you in your process. And you want a legitimate receipt from a licensed professional. If you have something corrected, you don't want that to be challenged in any way. And you have a right to live comfortably in your home. That is one of your landlord's obligations.
And so before we move on, I just want to remind everyone that you are watching the Cook County Bar Association live. Cook County Bar Association is the oldest African American law association in the country, and the Cook County Bar Association Law Referral Service number is the 312-630-1157, extension 1, if you have any questions or you have any issues with your landlord and you want some help. And just going back again, some of the things as we begin to wrap up, what about housing discrimination? What issue, what can a person do if they're discriminated against?
Absolutely. You have the right, the Fair Housing Act, I mean, you have the right to live in your home comfortably and to rent. You have the right to rent. It's an open market. You can't be discriminated against for the issues that you're more familiar with: race, class, gender, sexual orientation, religion. But if you have children,
Absolutely.
they can't discriminate against you. There are some limits that a landlord has in selecting a tenant, but that's more like pets. You have the right to go to your local or state agency and say, I feel as if they won't rent to me because I'm this type of person, and explain that evidence to them. Evidence, again, would be very important in that instance. So if you have any email or any track record or anything that tends to give you that inclination, you should provide that to whatever entity you're going to report to.
And some of the entities that the government agencies, that is the Chicago Commission on Human Rights, the Illinois Department of Human Rights, HUD also has a reporting agency that you can report to. And one of the things that we often do not do is we don't do it. We say, okay, it'll go away, but those agencies are there to help you. You have 180 days in some instances, and even in some instances you have a year to make that complaint. One of the things that you want to do, and we were discussing this earlier, is if you have a question and you have access to a computer, Google it. Look, just something very simple: tenant rights Chicago, tenant rights Evanston, and those will provide links so that you can say, okay, well, let me call this agency to see how they can help me, because I feel like I'm being discriminated. And it's awful is that, yeah, you do sometimes people can get discriminated against because they have children, and you cannot refuse, or a landlord or a potential landlord cannot refuse to rent to someone because they have children.
Yes, you definitely want to support an active landlord-tenant marketplace here in the city and throughout the state of Illinois. So hold these landlords to it. Hold them to a standard so that this stops. Don't encourage landlords to discriminate on any basis. So you have an obligation really to the community around you to report these instances,
Right,
so that it can stop more and more.
So there are two other things. I know our time is wrapping up, but two other things I wanted to talk about is landlord rights too. So I don't want it to seem like we're beating up on the landlord and we're so tenant focused, but landlords have rights too. Landlords have a right to access an apartment.
Thank you.
Access to premises of apartment if they give you reasonable notice, and that's usually 48 hours, I believe 22 days. And you can't, as a tenant, you can't say, well, I'm not letting you in. A landlord has a right to come in to, say, inspect their property, or if there's water just pouring down from the residents, or they need to come in and they need to check, but they can't just walk in. They have to give you a reasonable notice, and a reasonable notice usually is the 48-hour window.
Yes, but be reasonable with your landlord. If you realize that you are renting someone's property that they own and they have obligations to you, so in order to maintain those obligations, they need access to the property. So be reasonable. If they're not able to get in touch with you for days and days and you come home and you find them there, be understanding if they are there for a valid purpose. But be prepared as well. I think that's what you've been saying all along, is keep your property, keep your home in a condition in which it can be entered comfortably by your landlord. Now, your landlord, of course, is not going to go through your personal belongings, etc. Should not.
Right.
But you don't want your landlord to ever have an emergency from a tenant that's above you or below you, or from a fire or anything, and now you have to explain the condition of your unit because you were unprepared.
Right. And the other thing too is that if for some reason or another the landlord must enter, they usually are required to leave a notice that they entered the apartment for whatever the emergency purposes were. They have to leave a notice of that. And then the last thing that I wanted to say, because it looks like we have 1 minute left, is that did you know that if you are if you are a veteran and you want to break your lease, and you've been deployed for 29 days, you have a right and you're protected that you can break your lease.
That is wonderful. That's a wonderful benefit for our vets that might need it.
So again, I want to just thank everybody for chiming in. And as we wrap up, I want to thank you for watching the Cook County Bar Association Live. And again, I'm Felicia Simmons Stovall, and this is
Kelly Garner.
And last thing but not least, if you have any questions, call the Cook County Bar Association Lawyer Referral Service, and that's at 312-630-1157, extension 1. Anything else you could think of, Kelly, while we're here?
No.
You have a good time?
I did. Thank you.
Thanks again for watching. Good night.